Hon Martin Aldridge.
Thanks, Mr. Acting President. I rise tonight to talk on the Workers' Compensation and Injury Management Amendment Bill 2013, and I'm quite proud that this place is now dealing with this important piece of legislation. This bill will bring Western Australia into line with legislation passed in Commonwealth jurisdictions in late 2011 in the form of the Safety, Rehabilitation, Compensation Amendment Fair Protection for Firefighters Bill 2011. And it was the subject of some comments that I made in my first speech to this place earlier this year in relation to the inconsistencies that existed then and exist still tonight between the career firefighters engaged by the state of Western Australia and those engaged in Commonwealth jurisdictions such as those serving at our domestic and international airports around our country tonight. I was fortunate to be working in the Australian Parliament during the time that the Commonwealth Bill passed both houses, and I've also had the experience, as members would be aware, as serving both as a volunteer firefighter in my community and later as a career firefighter with the Fire and Rescue Service of Western Australia. It's important to recognise that there was a private member's bill in the 38th Parliament, as the Honourable Sue Ellery pointed out earlier in tonight's debate, introduced by the opposition, which substantially would have achieved what we are debating today. The National Party took that bill quite seriously and actually had made a decision to support the passage of that private member's bill through the other place. However, upon informing the government of our decision, were persuaded to wait for a further bill from the government which would have extended protections to both career and volunteer firefighters alike. That, in our view, was an offer too good to refuse, because whilst we would be protecting those important firefighters in our career fire service, we would be neglecting to consider the protections that were needed for the volunteers, the many volunteers in the state of Western Australia. Given the large majority of our firefighters in our state come from the volunteer services, and most of these regional electorates, most of these based in our regional electorates, I think that was the right decision to take. This was still an important turning point for this legislation, because as up until that point, we were trying to persuade, in particularly, the government departments involved in and around this legislation about the existence of scientific evidence that was building and forcing many other jurisdictions, not just in Australia but internationally, to take action to recognise the link between exposure as a firefighter and cancer. This was despite a comprehensive committee inquiry by the Senate Education, Employment and Workplace Relations Committee, which in September 2011 found the following. Chapter 2, paragraph 2.1. The science underpinning this legislation is pivotal to its justification. The committee received as evidence a large amount of the research that has been conducted into the link between firefighting and cancer. These studies were used to inform this report and are all publicly available. Given the quantity and quality of evidence presented, the committee is confident that a link between firefighting and an increased incidence of certain cancers has been demonstrated beyond doubt. I agree with the views of the Senate Education, Employment and Workplace Relations Legislation Committee in relation to the science, and I think over time the body of evidence that supports the decision of this place in passing this legislation will only further be reinforced, and in fact we may even be looking at other cancers in time being included in the schedule of prescribed cancers. As well as the report from the Senate committee, every member of the Australian Parliament, across every political party represented, supported the passage of those reforms. The government so far has honoured part of the commitment it made to the National Party to introduce a bill to provide further protections to career firefighters, and more specifically those employed under the Fire Brigades Act 1942. But the second bill, I guess, is the one that interests us to a greater extent due to the nature of the number of volunteers who serve our state of Western Australia, and the majority of them coming from the regional communities that we represent. We're yet to see the substance of that second bill, which, as I understand it, will be aimed at offering similar protections to volunteers and retired firefighters that could not be covered by this bill as a result of the definition of worker under the Workers' Compensation and Injury Management Act 1981. And I acknowledge that some other jurisdictions in Western Australia perhaps don't have this same problem, in that their workers' compensation acts in other states do compensate for arrangements for volunteers, and not specifically emergency service volunteers, but volunteers more broadly. The Act currently allows an employee to make a claim against the employer in relation to the contraction of a disease as a result of their exposure in the workplace. However, the burden of proof currently rests with the employee. This bill reverses that burden of proof to the employer to the extent that if a firefighter meets certain criteria, it will be presumed that it was a result of their exposure within the workplace, unless the employer or their insurer rebuts that presumption. The current law, as I understand it, allows for a firefighter to make a claim against their employer if they contract a disease such as cancer. However, these firefighters would be required to undertake adversarial, costly and often protracted legal proceedings to establish firstly the link between firefighting and cancer and causation between a specific fire incident and their specific illness. Undertaking such action whilst battling a disease as debilitating as cancer is not easily achieved. It is often recommended that firefighters faced with this scenario should focus on their recovery and their treatment, which often comes at a cost to the financial security of that firefighter and, in certain circumstances, their family. I note that this bill only provides protections for a member or officer of a permanent fire brigade established under the Fire Brigades Act 1942, and I understand that those definitions are contained within that Act in relation to a member or officer and a permanent fire brigade, to essentially mean that you would have to be an employee of the Career Fire and Rescue Service of Western Australia. This will leave firefighters employed in the private sector, on mine sites or at airports, without similar protections. The same will apply to firefighters employed by the Department of Parks and Wildlife, and perhaps by some other discrete agencies such as the Kings Park Board, for example. I recognise that there is perhaps at this time not sufficient scientific evidence to support a link between cancer and exposure whilst undertaking predominantly bush firefighting operations. However, in my view, that this is partly as a result that the scientific work thus far has been focused on the urban firefighting environment, where carcinogens released from synthetic materials are known to be far more toxic than those in the natural environment. I believe the government and governments across Australia need to consider this matter further to assist in assessing the risks to those firefighters who predominantly work within the natural environment. My comments here relate only to those engaged in the Department of Parks and Wildlife and other discrete agencies that I've mentioned, and not volunteers under the auspices of the Department of Fire and Emergency Services or local government. Volunteers in our 28,000 strong bushfire service respond to fires outside of the gazetted fire districts. So they are the fire districts that are gazetted by the Fire Brigades Act 1942. So members should not be confused by the name of this fire service. These volunteers respond to bushfires, car fires, house fires, factory fires, and even aviation fire. They do it with less personal protective equipment, less training, and usually less resources to assist them in combating the fires. I would argue that these volunteers in some instances would have a greater exposure to the carcinogens of firefighting than perhaps some of their career colleagues. One of the matters that I've raised directly with the Attorney General, and I'll ask him to address at some stage in tonight or tomorrow's debate, is in relation to the regulations of the Fire Brigade's Regulations 1943, and also in relation to Section 37 of the Bushfires Act 1954. Firstly, in relation to the Fire Brigade's Regulations 1943, Regulation 190, titled Entitlements After Accidents, Section 1, any officer or member of a volunteer fire brigade who has established a claim with the department's insurers as if he were a worker under the Workers' Compensation and Injury Management Act 1981 and any amendments thereof, by reason of personal injury by accident arising out of or in the course of his employment, shall be entitled to leave of absence from duty and shall receive during the period of incapacity such sum weekly as shall, together with any weekly payment by way of compensation, including child allowance, if any, payable by the department's insurers as if he were a worker under the Workers' Compensation and Injury Management Act 1981, and any amendments thereof be equal to his weekly wages, but not exceeding an amount per week equal to 1% of the prescribed amount. And the regulation goes on. The Bushfires Act 1954, Section 37, specifically subsection 2, for the purposes of a policy of insurance referred to in subsection 1A, the compensation that is payable for an injury and the purposes for which it is payable are the amounts and purposes that would apply if a volunteer firefighter were a worker and suffered that injury under the Workers' Compensation and Injury Management Act 1981, and where a reference to weekly earnings is necessary for calculating those amounts, the volunteer firefighter is deemed to have earned, and the section goes on. Specifically, whilst I support equivalent protections being provided to volunteers, I don't want them to be provided in perhaps an inadvertent way or as a unintended consequence of the passage of this legislation. And I guess the question that I would like answered at some stage during this debate is whether or not if this Act and regulations that I refer to, and there are other examples in the other emergency service acts, that require the engaging authority, whether it be the Department of Fire and Emergency Services or indeed a local government, to take out a adequate insurance policy, if you like, to protect its volunteers as if they were a worker under the Workers' Compensation and Injury Management Act 1981, whether or not through the definition of those acts and regulations, whether the passage of this bill, which is intended to provide protections to career fire and rescue service personnel, would then, by definition, also be applied to volunteer firefighters engaged under those other pieces of legislation. And more specifically, I think if the answer is possibly, then I guess those volunteer firefighters employed under the Bushfires Act 1954 then potentially would not receive those benefits, because the bill that we're dealing with tonight actually refers to firefighters engaged under the Fire Brigades Act 1942. But keeping in mind we actually do have some 2,000 volunteer fire and rescue service firefighters in this state engaged under the Fire Brigades Act 1942. So I think it's an interesting question that I would like the Attorney General to address at some stage during this debate, as to, I guess, assure me and this place that that won't occur, and that we so that this place, I guess, will retain control over the circumstances in which it provides equivalent protections to the volunteers serving our state. The other point that I wanted to make in relation to the bill that we're dealing with tonight is there has been some confusion in relation to the point at which it will apply. So I'm aware of the incidence of cancer amongst some of my former colleagues, and I've been to and been made aware of, a number of career firefighters that have passed away from what would have been eligible cancers under the Schedule 4A of this bill. And there are a number still battling those illnesses today in various states of treatment, and there has been a perception that this bill is going to help those people. My understanding and my interpretation of this bill is that if you have been diagnosed of your illness, and or you have already become incapacitated as a result of your illness prior to this bill receiving royal assent, then there will be no protections provided. However, I understand there has been a commitment made by the Commissioner of the Department of Fire and Emergency Services that I guess once the Parliament has decided that these protections are adequate and should be enacted, that through a system of ex gratia payments, we will ensure that those firefighters who otherwise would have been eligible to receive assistance through the workers' compensation arrangements will be provided for in an equivalent manner by the ex gratia systems that already exist. Section 49E of the bill refers to a review. The Minister must carry out a review of the operation and effectiveness of this division as soon as practicable after every 5th anniversary of the day on which the Workers' Compensation Injury Management Act 2013 Section 4 comes into operation. And I think this is really important, particularly when you look at Schedule 4A of the bill, which prescribes the exact 12 cancers that we have seen prescribed in Commonwealth jurisdiction, and the 13th item of Schedule 4A relates to a cancer of a kind prescribed by the regulations for the purposes of this schedule, and the qualifying period being the period prescribed by the regulations for such a cancer. And I think this is important because, going back to some of my earlier comments about, in my view, the body of scientific evidence is sufficient to support a link between exposure as a firefighter and a number of cancers which are prescribed in Schedule 4A, but it also allows for future scientific evidence and perhaps other evidence in the future being able to substantiate other types of illnesses that have been contracted or can be linked to the occupation of firefighting, which, as we all know, is a very hazardous firefight. And the Honourable Robin Chappell made some comments tonight in relation to the increased likelihood that as a firefighter you will be exposed. You are at greater risk of contracting one of these cancers than the general population, and that is also without factoring in, I guess, what's called the healthy worker effect, which is predominantly firefighters are generally fairly fit and healthy individuals, and without even factoring in that perhaps they even have ordinarily, if they were a sample of the population, they would have a lesser chance of contracting some diseases and illnesses, that even despite that they have a higher rate of occurrence in their population. Section 49C of the bill, let me just get the section, subsection 3B. Subsection 3 talks about, for the purposes of this section, a worker was employed as a firefighter if A, the worker was a member or officer of a permanent fire brigade established under the Fire Brigades Act 1942, and B, firefighting duties made up a substantial proportion of the workers' duties. Now, I noticed that firefighting duties isn't a term that's defined in section 49A earlier in the bill, and I doubt that it's a term that's defined in the Workers' Compensation Injury Management Act. But I would be interested in the Attorney General's view in relation to how perhaps the government interprets what firefighting duties are. I know that the community and probably many members think it's the act of putting water or wet stuff on the red stuff, but there are obviously firefighting is more complex than just the hydraulics of water, and there are a number of specialised units and within our fire services. To mention a few, the fire service in Western Australia has an air wing. It has a specialised equipment tender, it has an incident control vehicle, it has district officers, area managers, and a fire investigation unit. All of these sections are predominantly staffed by career firefighters of the Fire and Rescue Service of Western Australia under the Fire Brigades Act 1942. However, perhaps in some people's view, they may not be undertaking the act of firefighting, which is putting the wet stuff on the red stuff, but they are still working in and around fires, responding to fires. At the fire station that I was stationed at, which was Belmont Fire Station, we had, it was a two-appliance station. We had a frontline response pump and light tanker, and then we had what's called the incident control vehicle, which is a specialised unit within the Fire and Rescue Service, which helps I guess our area managers and district officers with the command and control of major incidents in the state. And the role, 50% of the time you were involved in one section of the fire station, and 50% of the time you were on the trucks doing the work of firefighting. And I think in that case you could say that a substantial portion of my duties was firefighting, because half of it was actually engaged in the work of frontline firefighting, and half the time you could perhaps argue it wasn't. But I guess when you're dealing with other sections like the fire investigation section, perhaps some of our district officers and area managers who respond to incidents of all types and nature, perhaps somebody could mount an argument that a substantial proportion of their duties is in fact not firefighting, even though they are career firefighters employed in the Fire and Rescue Service under the Fire Brigades Act 1942. And I would not want that instance to occur, because quite often these people have spent many years on the fire trucks, on fire stations. They're still responding to fires and other emergencies, and in my view they are still exposed to many of the dangerous toxins and chemicals that are emitted from firefighting. I'd like to conclude my remarks tonight just talking a bit about, I guess, I'm broadly satisfied with the bill that has been brought to this place to provide protections for those in our career fire services in the state. I think what I await with anticipation is the second bill, which will provide for our retired career firefighters and our volunteer firefighters who I've made the argument previously to government and not in this House that it is my firm view that some volunteers at some stations, in my view, would have a greater exposure than perhaps some career firefighters at career stations that we are aiming to protect tonight. And I think it's very difficult to, if you have a look at some of the science that's been established around this, it's very difficult to point to definitively to that incident or the level of incidents that you have to attend before you're considered high risk to the contraction of some disease. And I think that and that's reflected in Schedule 4. That's reflected in Schedule 4A of the Act, where the qualifying periods are based on the scientific evidence, and over time, for example, primary site brain cancer is a qualifying period of 5 years, whereas primary site esophageal cancer has a qualifying period of 25 years. So I think it's very difficult to draw lines between at which point you will be high risk, at which point you'll be low risk, and I think that it's important that we recognise that volunteers, in my view, are just as at risk of exposure to the carcinogens and the other chemicals and toxins that we are legislating, hopefully, to provide protections for our career personnel tonight, and that it's important that this Parliament receives that legislation as a matter of priority to ensure that only for a small amount of time we continue to have an inconsistency in relation to the protections that are provided to firefighters across our country. I understand that the second bill that the government intends to bring to the Parliament will be carried by the Minister for Emergency Services. I've had several conversations with the Minister about this, and he obviously has a good understanding of volunteer firefighting in this state, being a volunteer firefighter himself. And in responding to some of my concerns, or I guess in responding to some of the questions that I had about how we were going to make sure that we provided similar protections to volunteers, the Minister said this: "The government is committed to introducing equivalent presumptive coverage for volunteer firefighters. This will capture registered volunteer members of a brigade, group or unit under the Emergency Services Acts whose duties as a volunteer substantially involve responding to structural fires. Members of volunteer emergency service units may be covered in the event that they can satisfy all elements of the proposed legislation. No volunteers will be explicitly excluded from the proposed presumptive legislation." So I think that's a good indication that the Minister and the government is committed to bringing that second bill to the House, and I guess we'll wait and see to what extent it intends to provide those equivalent protections to our precious volunteers, and I think particularly the way in which we define or separate those volunteers who substantially respond to structure fires, because the point that I made tonight is that the majority of the state of Western Australia are outside of the gazetted fire districts of the Fire Brigades Act 1942. The response to all fire, regardless of whether it's a bushfire or a house fire or a plane that's crashed in a paddock, is the responsibility of the Bushfire Service under the Bushfires Act 1954, and currently those volunteers fall under the auspices of our local governments. So I think in concluding my remarks, I congratulate the government on bringing this bill. I hope that we can pass this bill and have it enacted as soon as possible. And I hope that the Attorney General might be able to address some of the issues that I've raised tonight in my second reading speech. Thank you. Yeah.